International relocation sounds simple, a new job, a fresh start, but legally, when children are involved, it can become one of the most complex areas of family law. Hi, I'm Jaswinder, Managing Director at Goldman Lawyers, an international law firm. Today I'm speaking with Jas Kerry Turner and explain how international relocations and cross-border questions and disputes arise in Australia and how they're dealt with and what you need to know before making any move.
How do international relocations or cross-border custody disputes work?
Thank you, Kerry, for your question. This issue typically arises in two situations. One, a parent who wants to move overseas with a child. Two, a child is taken overseas without the other parent's consent. They're the two main situations which involve relocation cases, either asking permission to remove a child and not getting that permission, or the child is taken then without consent. And legally, both situations are treated very differently. Britain's Family Law Act, previous presumption of equal shared parenting responsibilities removed, and courts now focus more directly on what arrangements are in the best interest of the child. Remembering now, we have to consider the Hague Convention on the Rights of the Child, the Hague Convention on the Civil Aspects of the International Child Abduction. So Australia can seek the return of the child wrongfully removed or retained overseas. But don't forget, you as a parent, your rights are subsumed under the rights of the child itself. So according to the updated framework, courts now must prioritise the safety of the child's relationships, practical considerations of relocation, and all from the child's viewpoint. Relocation is not a right, it must be justified. And if a parent wants to move overseas for work or family support, obtain consent from the other parents, apply to the family court. If a child is removed without permission, then it would be considered wrongful removal, and the other parent can apply for a return order under the Hague Convention. And courts act quickly in these cases, and you will get costs awarded against you. And it will be considered to be an irresponsible act. Assuming you can move because you're the primary carer is one of the biggest mistakes. Not formalizing this consent in writing, traveling without checking parenting orders, ignoring international legal consequences. One wrong step can trigger urgent court proceedings across multiple countries. So before making any move, check if there are existing parenting orders, check if there is any withholding of consent, or get consent from the other parent. Seek legal advice early. Consider mediation if there's a problem, because once a dispute starts, it becomes significantly more complex and costly to work across borders. When it comes to international custody, it's not about where you want to go. It's about what the law allows and what's best for the child. The earlier you understand your position, the more options you have. If you're dealing with international relocation or custody issues, we offer a confidential case assessment with the senior lawyer. We'll help you understand your options clearly and quickly